Section 73 of the Civil Procedure Code is a rule of procedure. It provides for distribution of assets at the time of execution. It is a cheap, speedy and expeditious method of execution. Now, when the execution is done, when the sale is executed and the proceeds of the execution sale are in the hands of the court, what is the method of distributing these proceeds is stated in section 73 subclause 1. Section 73 subclause 1 says that when assets are held by the court and even before the receipt of such assets by the court, several persons, more than one person, have applied to the court and they apply for the execution of their decrees. That means they are several decree holders. They apply to the court for the execution of their different decrees, and the decrees are for the payment of money, and that decree of the several decree holders have been passed against the same judgment debtor and they have not been satisfied. In such conditions, the assets which are available with the court shall be rateably distributed among all these persons after deducting the costs of realization of those assets. This is provided under section 73 subclause 1. For example, let us look into an illustration. Now, there is a person A who obtains a decree against a person J for rupees 10,000 and he applies to the court for execution of that decree, and he applies for the mode of execution of that decree, that is attachment and sale of J's property. Accordingly, the property is attached. And again, B is another person who also obtains a decree against the same J in the same court, but it is for rupees 5,000. Now, when he also applies for attachment and sale of the same property, and that was attached, the same property was attached in A's decree. This property is afterwards sold by the court, and in execution of A's decree, it was sold for rupees 7,500. Now, 7,500 is available with the court. There are two people who have applied for the execution. Now, this has to be rateably distributed among A and B, which are the two decree holders. So, it will be distributed in a manner rateable among the two, where A will be paid rupees 5,000 and B will be paid rupees 2,500. So, the meaning of this, where all of the assets are liable to be rateably distributed, these assets are distributed to the persons. But suppose these assets are rateably distributed and paid to a person who is not entitled to receive the same. Section 73 subclause 2 says that if in such case that person who is entitled to receive can sue such person who has received the assets and compel that person to refund the assets. That is provided under section 73 subclause 2. That means when the assets are rateably distributed by mistake or erroneously or by some other reason, it is paid to a person and that person is not entitled in law to receive that assets, then that person who is actually entitled can sue the person who has received the assets, compelling him to refund the asset. This has been provided under section 73 subclause 2. 73 subclause 3 says that nothing in this section affects any right of the government, which means that the government has a priority over all the debts. So, whatever assets are available, if the government applies for these assets or these things or property which is in the hands of the court, which is in the form of payment of money, then the government will get the priority for the debts and the other decree holders will be taken as secondary, they will be secondary to the government. That means when the government applies for this, then the government will get the priority and the other decree holders will not receive the assets until the government has taken what is due to the government. Now, here is an illustration for that purpose. In the previous illustration, we had spoken about two people, that is A and J. Now, instead of A, government obtains a decree. So, government is a decree holder. Government obtains a decree against J and the property is attached by the government. Now, there again B also obtains a decree against J. Now, there is government and B. There are two decree holders. The property is sold in execution. The government is entitled to receive its dues it can recover its dues by claiming priority over B's dues. That means first the government has to be paid and then B's dues will be paid. But in this case, suppose the government, before it applies for payment, B applies and takes away the amount and the government does not apply in time, then as there is nothing to be paid, government cannot claim priority over that. That means once the amount is paid by another or once an amount is received by somebody else, then the government cannot retain its priority. Now, what is the object of this provision? First of all, this provision places all decree holders on an equal footing, whether they have applied earlier for the execution or whether they have a priority in their obtaining a decree or in applying for any attachment, irrespective of their applying for the distribution of assets or irrespective of their attachment or the time of the attachment or priority in attachment, or whether they have made an application earlier or later, all the decree holders are considered as equal. In this case, equitable disposition of assets shall be made among those decree holders who have rival claims against each other and without taking recourse to any different, separate, independent proceedings. This is stated in Muhammad Jan versus Haji Abdul Sattar, where the court said that the object of this purpose is to see that there is a equitable treatment of all the decree holders and the assets will be disposed of without asking them to go to different, independent, separate proceedings. Now, what are the conditions for this particular provision to operate? First of all, the condition is that the person who applies for rateable distribution should have obtained a decree, and secondly, he should have applied for execution of the decree to the appropriate court. This is the first condition. Secondly, that application should be made before the receipt of the assets by the court. Then only he will be considered for rateable distribution. Thirdly, the assets of which the rateable distribution is claimed must be the assets which is held by the court. He cannot ask for the assets which are not in the hands of the court. So, the rateable distribution will be done of only those assets which are held by the court. Fourthly, the attaching creditor and the decree holder who are claiming to participate in the assets should be the holders of decrees for payment of money, not for any other decree. And the fifth one is, such decree should have been obtained against the same judgment debtor. This also has been stated in the same case, that is Muhammad Jan versus Haji Abdul Sattar. Now, what are the assets available for rateable distribution? Let us look into it. First of all, sale proceeds realized from auction sale. They are all sale proceeds or assets which are available. They are in the hands of the court. Sale proceeds in the hands of decree holder purchaser. Suppose a decree holder purchases the property, the sale proceeds in his hand are also available for rateable distribution. Then deposits made by the defaulting purchaser, as it is also received by the court, that is also available for rateable distribution. Then salary of government servant under the attachment, that salary is attached by the court and therefore it is held by the court and it is also available for rateable distribution. Money which is deposited by surety to release attachment, or money which is paid in garnishee proceedings, money which is paid in execution proceedings, money which is paid under prohibitory orders, money which is paid to avoid attachment, money which is realized in execution of the decree. All these monies are paid in the court, they are in the hands of the court, and such other monies are all assets available for rateable distribution among the decree holders who apply for this purpose. Now, what are the assets which are not available for rateable distribution? Let us look into that. Deposit of earnest money. Now, this is something which is not distributable among the decree holders. Money which is paid for removal of the attachment. This cannot be available for rateable distribution. Money paid privately by judgment debtor to the decree holder, that is not deposited in the court, that cannot be available for rateable distribution. Then money paid by the judgment debtor to get himself relieved from the debt, or money paid to the decree holder by the surety, or money which is paid in court towards a decree against a third party. In this case, the third party is entitled to receive it and it is not available for rateable distribution. Money which is paid as security, it is not available for rateable distribution. Money which is paid for specific purpose, for example to avert arrest, then that will be utilized for that purpose only. It is not distributed among the decree holders. Money which is deposited to set aside sale. Money which is realized under attachment before judgment. Such monies are not available for rateable distribution because they are not monies which are held on the behalf of the decree holders. They are, though they are paid in the court, they are not available for rateable distribution. Then 73 subclause 2, as we saw, provides for suit for refund. Here, if the assets are wrongly distributed among persons who are not entitled to receive the assets, then a suit lies for that purpose, that is to refund the assets which are wrongly distributed. And the cause of action arises immediately when the amount is paid to that person. Now, the period of limitation is there for this purpose, that is 3 years from the date of payment, he has to file a suit for the purpose of refund of the assets. This is under the Limitation Act. Coming to section 73 subclause 3. What is the priority of government debts? What is the meaning of this? Now, the object of priority we can see is that a sovereign is performing several functions for his people, and therefore, in order to perform those functions, basically law and order, it needs the necessary funds. Therefore, always the priority is in the hands of the sovereign. This has been introduced as a concept of crown sovereignty, which comes from the British law or the English law, where sovereign is supreme and he has a priority over everything. So, once the sovereign's debts are fulfilled, then the other debts will they will follow. But there are certain criticisms against this. There are some opinions that now sovereign or a state as a sovereign performs several other functions like welfare functions. It runs businesses, it runs several things where profit is also a part of that business, and therefore state should be not treated separately, and state also should be able to waive this right, that is a sovereign priority. But this priority of government debts provision is supported also by some cases where, for example, in Builders Supply Corporation versus Union of India, the Supreme Court held in 1965 that as the object of the priority is that the sovereign should be able to discharge its functions, and for all the functions which it performs for the purpose of the people, it needs to have necessary funds, and therefore always the priority should be there in the hands of the sovereign. So, priority can be claimed, but in what conditions? Now, section 73 subclause 3 says that government rights will not be affected. The powers of the government or the rights of the government shall not be affected. That means, now one question is there, that is, as soon as the question of rateable distribution is determined, the rights of the parties are crystallized. That means, once the court determines which parties are entitled to claim the priority or get the rateable distribution of their assets, their rights are crystallized. So, if the government has to claim the priority, it must make an application before the assets are paid to the decree holders actually. If it does not do so, if the state does not apply to the court for payment of its dues and some decree holder takes away the amount, suppose the state applies late, before that the decree holders apply to the court and the amount is already distributed under this provision, then the government cannot follow that amount in the hands of the decree holders. The government loses the priority. So, if the state has to claim the priority, it must apply before the payment of its dues to the court for the priority to be claimed. Then the amount will be first distributed according to the dues of the state and then will be distributed to the other decree holders. Whether there is an appeal to this provision is a question. Now, prior to the amendment of a definition of decree in 1976, an order made under this section, that is rateable distribution of assets, was an appealable order. It was appealable because it was deemed to be a decree. But after the amendment, the order passed under 73 section is not appealable because it is not appealable as a decree. It is not a deemed decree, and As it is not a decree, it is not appealable, but it is subject to revision because it comes under the definition of a case decided. If the conditions under section 115 are applicable, then the order is subject to revision under section 115 of the Civil Procedure Code. So, to summarize this, section 73 of the Civil Procedure Code provides for rateable distribution of assets among several decree holders against the same judgment debtor. Then it also provides for refund of the amount paid if the assets are wrongly distributed to somebody else or to a person who is not entitled. It also provides under subsection 3 for the priority of the government debts over the others. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.